let me ask you something. Are your contracts actually legally legit, like rock solid, airtight, ready for anything legit? Because if you've ever had that uh-oh moment before hitting send on a contract, or worse, after something goes sideways, you're not alone, and I have your back. I'm Paige, your go-to small business attorney and founder of The Legal Page, where we make contracts make sense and actually protect you. Now listen up. Our biggest sale of the year on contract templates is just around the corner. And if you want early access, special bonuses, and all the legal tools your business needs to stay protected, you've got to get on the list. So just head over to tlpinsider.com and pop your name in. That's how you'll get the inside scoop before anyone else, plus some fun surprises I only share with my email crew. Again, that's tlpinsider.com. Alrighty, let's get into this episode. Hey there, I'm Paige Griffith, your host, an attorney for small business owners, and the founder of The Legal Page. I help online businesses and creatives get legally legit in no time. In this podcast, I break down and simplify legal talk while providing practical business guidance every step of the way. With over a decade of experience in both entrepreneurship and the law, think of me as your go-to legal resource, here to tackle all those what-if scenarios so that you can focus on what you do best, growing your business. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney, so be sure to seek legal counsel for personalized advice. Welcome to the Legally Legit Podcast. Okay, everyone, we have a treat today. We have myself and Alicia Suazo, who is another attorney here at the Legal Page. Alicia, hi.
Hi.
I am very excited, Alicia. You've been on the team for over 3-4 years now.
3 years, yeah.
So she knows everything, all the ins and outs of the legalities of TLP and our industry. She is an attorney herself and has practiced in various different places. So Alicia, introduce yourself.
Yeah, I'm Alicia. I have been an attorney since 2018. I went to Gonzaga Law School in Spokane, Washington, though I'm all the way in Florida now. So it's kind of an interesting switch going from the Pacific Northwest to one of the hottest states, but I love it.
Yeah, we're always on calls and Alicia's just got this beautiful background of sunshine always. And there's a lot of us here in Montana and like the Midwest, and we're like, our weather is not that nice. So I'm really glad that you have good weather now almost all the time, minus hurricane season. But yeah, so what Alicia and I are going to kind of do is every so often we're going to do some random rapid fire legal Q&As. And this is all coming from our TLP community on Facebook, our shop inbox, my DMs, my email, various affiliates or like educators that we work with, and the questions that continually come up in their memberships and online courses and communities. So we're just going to get into it. How does that sound?
Yeah, that sounds great. Let's go.
Okay. So the first one's kind of a softball. And we're going to kind of start with contract basics, cancellations, refunds, other issues. But this one came specifically from our Facebook group. A client returned their wedding contract, but only initialed next to their name instead of fully signing it. Is that legally binding, or do I resend it? So when I first saw this question pop up in the group, I was like, well, I feel like you're about halfway there, because in most jurisdictions, it could be legally binding with an initial, because usually you can go in, if there was any disputes later on, you could go in and, have some proof that that was their actual initial. But in most cases, you always want people to sign their first and their last name as it's stated in the signature lines of a contract. So a full signature. And then you also want them to either print or like online contracts, you're going to have them type out their full name, what their designation is. Like if you're working with another company, for example, I would always sign as Paige Griffith, owner, the Legal Page LLC, and then date it. So in my opinion, and Alicia, tell me if yours is different, I think at this point, since really they've just initialed, you've kind of caught it early on, I would just have them sign it again. Send back and say, in
Yeah.
order for this to be legally binding, I need you to sign your full first and last name and then just print it as my contract platform asks you to. Anything else?
Yeah, I think it's hard for people to go back to their clients, especially maybe it was hard to get signatures in the first place.
Yeah.
But, it's just better to just go back and be like, hey, I'm so sorry. Can you just sign your full name? It's just easier in the long run. And it's going to save you that argument that may come up if something does happen later on.
Yeah, it's like the clarity that you need, you kind of want. I feel
Yes.
when I say at the beginning, like you're 50% of the way there, and then we are just we're always looking for how to avoid potential future disputes. And I don't ever want you in a position where they're like, I didn't sign that, or whatever it could be. And the last thing that I will say here before we move on is a lot of small business owners don't sign last, or they will send their contract over already signed by themselves as a business owner. And what happens then is if they were to initial under their signature line, because I'm guessing this is like an online contract sending platform where they can, like draw their
Right.
name. And so a lot of people, like I've initialed things before. And what we're saying here is, yes, that is legally binding. It's just what happens if there was a clarity dispute or any type of potential future dispute. We just don't want you in that situation. And what happens is if there was already two parties with signature lines at the bottom and then they go pay their retainer, you have a fully executed, valid, legally binding contract. And so it's always best to wait to sign the contract in case things like this pop up, in case they forget to initial next to a specific clause, in case they initial the signature line and you really want their full signature. Then you have a little bit of leverage there to say, like, the contract, isn't complete yet. And I also haven't signed. So
Totally. Just don't forget to sign it because we have that too, where people just forget to sign it and then they don't have a legally binding contract. And you have to have both sets of signatures to have a legally binding contract. And I think people forget that.
Good point. I would say once a week or at least every 2 weeks, you guys go back into your CRM system or your online contact sending platform and just check to make sure that you have co-signed every single contract that
Yes.
your clients have signed, because I see that and Alicia sees it more often than we would like.
Yes, exactly.
Okay, this is kind of along the same lines. So, if a client signs the contract but never pays the retainer, is the contract still valid? What are your thoughts?
Yeah, so the contract is still valid, but they are in breach of that contract. So you're going to have to do something about that. Whether that is stop all services. So if you're doing graphic design and you're designing things for them right off the bat after the retainer is paid, then you're going to want to stop those services until you get paid. Same with the wedding contract. So if you're a wedding photographer and you don't have that retainer, then legally they're not on your books yet. So don't write their date down on your calendar until they have that retainer and let them know of that. So I definitely think that the contract is in place, but they're in breach of it.
Yeah. So, what we have done here at the legal page is in the fee and retainer clause, we have a very specific sentence that says this agreement does not become effective until all parties have signed on the bottom dotted line and the retainer has been paid. So that's a fully executed agreement. So what Alicia's saying is, like, you have a contract that's signed by all parties, but you don't have it becoming fully effective, like your services becoming fully effective. And that allows you to have a breach of contract with that kind of one liner in there.
Right.
And we have it at the top portion as well, like when we're talking about when we're talking about the parties and you're introducing the parties and you're talking about the effective date. So we have it in various places in the contract. Okay, next question. With rising costs, how do we add a right to adjust pricing clause to our contract, and what should it actually say? So I'm going to take this one because I've been talking about it a lot on various calls that I've been doing lately. And a right to adjust pricing clause, it can either be language like a paragraph that you're adding into your fee and retainer clause, or it can be a solo standalone clause, and that would be like right after your fee and retainer clause. And this is for people with wholesale pricing. that wholesale cost of goods is included in their services. So think here florists, caterers, bakers, mobile bar companies, people that they're getting inventory from a wholesaler that's included in their services, and it's a huge part of their package price. So I'm just going to take florists for example. A right to adjust pricing clause would say in the event that wholesale price increase exponentially or something happens in the industry or industry wide, there's a lot of different language that you can use there. That you will share those costs with the clients and you have the right to adjust your pricing. And this all aligns with that final invoice. So, of course, with florists, you would send a final invoice once you finalize all of their floral choices, everything that they're going to have at their wedding or event, and you're going to have them pay before you order those wholesale flowers. And you're probably getting your final numbers from your wholesaler at that time. And what we're seeing right now with florists is tariffs are massively going to change wholesale pricing from what they originally quoted their clients 6, 12, 18 months ago when they booked them for their wedding or event in 2025.
Right.
So if they had this clause in there, they basically have the ability to shift and push those costs onto their clients. And we're just talking here the wholesale cost of goods. You're not going to like massively change your pricing and package as a whole and your services. But you're just changing, like if it's a 5% increase, a 10% increase, a 20% increase, only in those wholesale cost of goods. And you want to be really, really specific in your clause to say just that. So your clients don't think you're kind of nickel and diming them and like completely changing your pricing on them last minute. This is truly only for the inventory that you need to get to complete your services. So yeah, the other thing that I would say here is if you don't have this in your contract, it is more of an uphill battle to shift those costs over to your clients. And so you have two options here. You can tell your clients like there's been an industry wide shift, that tariffs are affecting wholesale pricing as a whole. And so I have to offset my costs and according to my wholesalers pricing right now, this is what it will be. I just wanted to let you know if you want to like shift anything with your packaging or change floral selections or the same with caterers and whatnot. And then the one you could go that route and they could push back and then you don't really have any leverage, right? Because there wasn't anything in your contract. But you could also just not do anything and kind of eat those costs. And I know that's not what people want to hear. But I've heard from a lot of educators in the industry, if you have done the proper markup with your
Right.
overall package, you can really assume those costs yourself and just take it as an additional expense to your business. And yes, it's unfortunate, but that's why you have to properly mark up your services from the get-go. And so when I was talking to some industry thought leaders, they were saying, people who have been in business for a while, they kind of know how this goes. They know how the economy fluctuates and they need to be prepared in any type of instance. Not that anyone knew that like massive tariff spikes were coming anytime soon, but we have to be prepared for that as service-based providers, and particularly if you have wholesale cost of goods included in your services. So anything you want to add there?
Yeah, I think just going off of what you said, if you don't have those wholesale cost of goods and you're still worried about inflation, you should be calculating a good amount of margin for inflation for the next 2 years. I mean, people are booking you 2 years out. So that's the kind of margin you're going to need. Whatever the economy gives you, you have enough margin that you're not sweating that.
Yeah, and a lot of times when I was talking to people, it's a few $100s.
Right.
Hopefully it's not thousands of dollars. If you have a package of that caliber, like you should be shifting those costs onto your clients. And honestly, they probably expect it at that point if you have that high end of a wedding and like that much inventory that you have to produce. So I would definitely, it's kind of a case by case basis, but it's also a really good learning lesson for newer business owners who haven't appropriately marked up their service package enough. And then the last thing that I will say here, Alicia, actually, I was in a DM with someone and I was just voice messaging with this person. I got their DM and I do this a lot, you guys. I hope you know this. I will just randomly voice message people back instead of typing. It's usually faster for me. And they were we were talking back and forth. They were a stationer, I believe, and so they were
Okay.
having issues with the wholesale price of their
Mm.
stationery goods. And the one thing I told them was, you know what? Just remember that for whatever reason, we're always second guessing it as stationers or florists or I know other type of industry professionals. But you know who doesn't second guess it? Caterers. They're
Yeah.
like, sorry, you have to pay this additional cost if you want me to produce food at your event. And like mobile bar owners, they're like, yeah, I'm not going to get that liquor for you. It's way too expensive. And you can decide on a different type of liquor or you can pay the increase in cost. It's like a no holds bar kind of thing. And it's really interesting if we can kind of be empowered to understand that a lot of other business owners are like, sorry, this is just what's happening industry wide and you're going to have to pay for it. We're all assuming those costs as consumers right now. And so it's a mental shift for us as service-based providers too, that we have to allow our consumers and our clients as well to kind of bear those costs.
Absolutely.
Okay, so next question is if my contract says travel fees may apply, do I need to specify the amount up front or can I invoice later? I'm going to have you take this one because you do a lot with travel fees for TLP.
You need a travel fee clause in your contract. So let's say that they don't even have travel fees, that they're doing their venue right next door to where you live. It's still good to have that in there just in case. Maybe their church is over the travel limit that you have, but their venue's right next door. You never know. So having that in there is just another safety net. They know what your prices are up front. There's no second guessing. And that way it's in there for every single client, whether you do have travel fees or you don't. So that's why we have such thorough contracts. And sometimes we have people that say, hey, they're so long. Why are they so long? Well, this is why we cover every situation just in case. And that way you're always, always covered.
Yeah, and so a lot of times we get asked this question like what happens if they don't have the actual location of their event?
Sure.
What do I do in my contract because travel fees may apply in that instance? I'm not totally sure where they're actually going to host their elopement per se if they're a photographer. I always say have a very specific vicinity at least in your contract because travel fees may apply is so broad and it can be interpreted so many different ways that your clients, I will tell you, will walk all over you when it comes to a sentence like that. So, what Alicia is saying is like, you have to be so clear and so concrete that there's no questions from your clients on what your travel fees actually are. So usually we do a zip code. We have found also, I'm going to explain here issues with zip codes. So if you can do a zip code but also put in the actual address of the location of the event. And so for some people maybe it's like, hey, let's choose a tentative location around here. I'm going to put this as the base location and address and we'll do within a 50-mile radius of that location, or maybe it's an 80-mile radius or 100-mile radius. Maybe as an elopement photographer, you've done your markup enough that you're still not sure. You're going to do some location scouting, but it's going to be in this general vicinity and location. And then if they change from that location, you have the right to add on additional travel fees. And then your clause is going to explain what that is. If it's beyond, 100 miles of that location, then you're probably going to require either additional fees for your gas and your mileage and of course your time traveling there, or maybe you also need a place to stay, so you're going to have lodging included in that as well. Of course it's far beyond that, or you have to go to a different state or you have to fly, then we've got per diems included. So you just want to really explain that and reiterate it again and again and again to your clients. So I will also say that yes, you want that in your base contract, but you also want to explain that to your clients throughout your workflow with them, especially with people like that are traveling a lot for their clients. I'm talking here elopement photographers or adventure photographers as a whole. Even if you're doing adventure sessions, things can change, locations can change, and your clients need to know what that means because you probably priced it based on an original location that you were thinking of. So tell them that throughout the process. Don't just like rely heavily on your contract. Yes, it's there to save you, but if you can tell them multiple times in email communication, that, they haven't chose a location yet, or, oh, okay, you are changing the location. Here's what my business practices are surrounding that. And then it mirrors the language in your contract, then you're good to go there.
Yeah, and I think one thing that we were talking about is margins in your business.
Mhm.
If you're flying or you have a hotel that you may or may not stay in, get travel insurance and add that into your cost of the travel fee. So that shouldn't necessarily be on your clients, but it should be added into the whole business cost and package cost that you're presenting to your client.
Yeah, I'm a huge proponent of always getting refundable tickets, refundable lodging, and putting it on your business expense, whether that's
Right.
your debit card or your credit card, and not having your clients pay for it. Because I've seen situations where, like, we had this recently, I think, in the Facebook group where they said, well, my clients booked it, but then they were only able to get a travel voucher for me because we had to cancel or something happened. And now I just like I don't know, something, or maybe they paid for it, but they only have a travel voucher. That's what it was. So the client or the company paid for it. And then they only got a travel voucher back, and so they were out of money. And I was just kind of like, well, that's kind of what you chose. And
Right.
like, so you need to make sure that it all can come down to dollars at the end of the day in a refund situation. And then Alicia also mentioned travel insurance that would behoove you all the time to do, especially if you are traveling a lot for your services. All right, the next question is one that we continually get, and I think we're going to continue to get throughout 2025 and into 2026 with uncertainty and people like just changing things up. So this question is: a client wants a full refund because they quote unquote changed their mind. Do I legally have to give it to them if they signed a non-refundable retainer? I'm also going to add in here, Alicia, you probably say no right away, but then what if they push back and they start threatening bad reviews or things along those lines? This is the question that we are getting just double or triple whammies a day.
Yeah, it's so hard. First of all, I think clients threatening you on social media is not as scary as some people think it is. It can get there, but don't be threatened by that. First of all, you have a contract in place for a reason that protects you. Your contract is only as good as you enforce it. Paige says this all the time, and it's so true. So if you're not willing to enforce it, then what good is it to have it? So definitely no, you don't get to give them a non-refundable retainer. And depending on when they're canceling, you may have other payments that you get to keep as well. But here's the thing, threatening and bad reviews, you can comment, you can respond to those, you can report them. There are ways to refute it. And if they do a chargeback, if you have a valid contract, you can, refute that and a lot of times win.
Yep.
So I would say don't be afraid of something until it actually happens and just enforce your contract as much as possible. And maybe even credit them something else. Maybe they just need a solo shoot. If they break up with their, significant other, maybe they want to do a solo shoot and you could just move that retainer over to something else if you want to be really nice about it. So there are ways to mitigate this for clients if you're feeling bad about it. But we would say don't feel bad about it. It's in your contract.
Yeah, it's in your contract, and then you can always base it in logic as well. Sometimes they just need to know like why it's a non-refundable retainer. And maybe your contract doesn't completely spell that out. A lot of ours do, on
Right.
what that opportunity cost is, where you're saying no to other clients for that date. Go get yourself some good proof when clients are starting to poke the bear a little bit. Go back and look through your inquiries. If you have inquiries that were asking for that date, and then you were able to respond to them and say, I am so sorry, I am booked. Boom. You have so much proof that you just had a massive opportunity cost that you could have booked another client. And we're talking here, you guys, for like weddings and events that are booked a far enough in advance, or far enough ways in advance that it's really, really hard to rebook a full day of services if they're just changing their mind 60 days out, 90 days out. Like everyone else that could have booked you has already booked the rest of their vendors for their event. Um, and so go do that. And then also, like, if you have performed any services for them, anything at all, what are the hours that you have completed service wise for them? Whether that's been back end work of, preparation, any mood boards, any timelines, any email communication back and forth, like that is your time and energy working for their event that you already said yes to. So go do yourself a favor and calculate out all of that and have it in writing, so that you can show, if it ever were to get to that point, that you have performed at least some services. Because what they think is you haven't done anything. There's no deliverables. We're talking here photographers, videographers, like florists sometimes too, or DJ. I mean, like there's so many people that don't perform the services until day of. Planners are a little bit different. And then I would also say like elopement photographers are a little bit different because they are rendering a lot of planning services at the get-go. And so that's really important to put in your clause too when you're talking about your non-refundable retainer and your fee and retainer clause. But for all of these other people, like you are performing some types of services, and then you also have a massive opportunity cost. So they sometimes it just needs to be rooted in that. And you can take what we're saying here, you guys, put it into Chat GPT, change that into your own brand tone and voice so that you can have a really nice, kind, eloquent, professional, but legal based email response back to them, that explains all of this that we just said. And then of course, if they start doing some pushback, like Alicia said, you do have a little bit of wiggle room there, to try your best to resolve the situation and kind of mitigate any potential yuckiness that could occur online or bad reviews or things along those lines. But bad reviews nowadays, I feel like clients are just, they're threatening them right and left because
Mhm.
they just think their money is so much more important than your money. And that's not the case. Like everyone's money is important now. It's like all the time, not just nowadays, but it was at the very get-go too. But particularly now. And you have to stand your ground. You have to be willing to enforce your contract. Otherwise, why is it there? Okay, we tied that up with a bow. I feel like I could go down that rabbit hole, and you can tell I get really heated about that. But non-refundable retainer language is there for a reason. I don't know why there's some groups that just like explode into hundreds of comments on a thread that is like, no, you have to totally give it back. And Alicia and I will die on this hill that you do not have to give back that non-refundable retainer. And if the whole industry was going to start giving back non-refundable retainers, then why do you even have one to begin with? So like, let's
Right.
not create this like massive wide industry standard. Let's keep it how it is right now.
I actually just found a federal case yesterday. So we're
Mm.
not just talking about this, we have cases behind us talking about how retainers are specifically for holding a date on a service provider's calendar. It's in a federal court case. If you go to court, we'll send you this case. We'll put it in the show notes. You guys can use it for authority. We're not just saying this to say this, it is consistent with legal cases.
And then when you're using that case, what you'll have to do is compare it to your own situation. So you will have to show the judge or some type of mediator or arbiter, or maybe you're in some small claims court or something along those lines. Hopefully, you don't even have to get there, you guys. Hopefully, you can just say this to your client and kind of explain all of the legal reasoning behind why your services have A, either already been rendered, or B, there's a massive opportunity cost. And here's my documentation behind why I do this and have to say no to other clients. So, yeah, love that. Thanks for adding that in. Let's rapid fire through some more here. How should I officially document a cancellation? Is an email enough? And what happens if I send a cancellation agreement, but the client never signs? You can take this one.
Yeah, so email can be enough. What we recommend is, though, having a contract. A cancellation contract is separate from the clauses in your contract, and it basically lays out exactly what you're refunding, if anything, why they're canceling potentially, and that it's a confirmation that you are canceling the contract. There's no confusion with those signatures, and that way it's just automatically terminated once they sign the cancellation agreement. And that's just really the best way to wrap up a client who's canceling with a bow. So that's usually what we recommend. If someone's ghosting you and they're upset and they're not signing, then we would recommend highlighting some of those important clauses, kind of putting them in maybe maybe not chat GPT, but making it more of your tone, your voice, putting it in an email and saying, this is a cancellation and a confirmation of cancellation. So, and then just leaving it out in the universe for them to understand. And that way you have some proof that, yes, I did confirm cancellation, and they can't come back to you later and say, well, I did cancel or I didn't cancel, and, all of that. So that's kind of the steps that we would take with that.
Yeah, I mean, the name of the game here is like what happens with people's fees that they've
Yeah.
paid in a cancellation situation. And so, email documentation, usually enough. Make sure that you're having like confirmation of receipt of their cancellation. So, you're sending that back to them. If they're just, if they said it on a call, they gave you a phone call, you need to document that and send it back to them. And then always we recommend sending that cancellation contract. I wouldn't say 9 times out of 10 they sign it. Honestly, I think it's more like 7 times out of 10 they sign it. And so for that, 20-30% of the time where clients are just going to ghost you and not sign it, we will link a really good blog for you guys that we have in the episode description and show notes for you on like what Alicia just said. If they are not signing the cancellation contract, here's what you need to do. You kind of like take pieces of that cancellation contract and send it back to them, because what is occurring is it's kind of like a unilateral cancellation at that point. They notified you of cancellation, but there's no like signatures to solidify the termination of your contract and your services. And basically you have to like tell them, all right, we're done, and I'm going to open up that date again to other people. Or maybe it's a website designer that has a cancellation from a client, and now they have like a 2-week period of time where they can render services for other clients. And so you need to be able to like off board that person who notified you of cancellation and they're just ghosting you. So it's like really important in a lot of various situations that you solidify that, and kind of it's like you want to notify them again, and then send the final confirmation email. Uh, Always try to get the cancellation contract signed, but you can also do it via email. We recommend the former, because a 4-cornered document signed by everyone is end of day always going to serve you best for any potential disputes that could come up with, you didn't give me the partial refund that I asked for and we canceled. And we have seen that, you guys. People come back like 12 months later and they're like, wait a second. I was just talking to someone and I should have gotten a partial refund from you. They can pop out of nowhere. So try to resolve that with a signed cancellation contract. All right.
Yeah,
Very
we've seen
last.
people hold refunds until they sign, and that's fine too if that's the way you want to do it. Where you're holding their refund, not
Mhm.
necessarily ransom, but that way it kind of forces them to sign the contract before they can receive the money back. And that way, again, it's just wrapped up in a clean bow and you can just move on to other clients.
Yeah, it's leverage, right? You have leverage if there is any type of partial refund situation. And if they do want money back, which they probably do, and you're willing to give it in some respect, maybe they canceled, but they paid, way beyond just the retainer amount. And you just feel like you haven't really deserved that final payment yet. Or, your clients have been just poking it, like asking for that partial refund, and you're just at a place where you feel like you just want to move on and give it to them. I would definitely use that as leverage and sign a full cancellation contract and explain what that partial refund is for, but that they will not get anything beyond that, like the non-refundable, non-transferable retainer. Okay, so last question here. My client is threatening a credit card chargeback after a wedding, even though they signed a contract and I delivered. What can I do? Oh, we hate credit card chargeback situations. What can you do, Alicia? I don't know. I mean,
Well, with the contract, there you do have that amazing proof, and I would fight it. So when you don't have a contract and you just have some oral agreements, it's a little harder to fight because these credit card companies don't know exactly what was agreed to. But if you're sending them a signed, delivered contract, and then you even send them an email where you deliver images and you've completed services, that's all going to be amazing evidence to fight that chargeback. And we have had several people be able to win these chargeback disputes because they have a contract in place. And I mean, they have a TLP contract in place, which is even better. So that's all you need to know.
Yeah, that's really it. There's no way around chargebacks if you're letting people pay via card. And so you just kind of have to be ready for all of this. Contract is your best bet and evidence and proof. And then also, if you delivered any services or completed, delivery post event, then you also will send in that documentation as well. And yes, it's not fun. Like you do have to fight it. Definitely fight it. And that's just kind of the cost of doing business right now with credit card land and debit card land. So just be aware of that. If you want to completely avoid it, the only way to avoid it is cash and check. So, um,
Yeah, I mean, even checks bounce. So, I mean, you're always going to have some kind of risk when you're taking money, and this is just our modern day risk. So,
yeah. Okay. Other contract questions. Do I have to dot, dot, dot? If I am photographing a high school senior, should the parent, the senior,
mm,
or both sign the contract? What about seniors who are 18? What about college seniors and their parents are still paying for the photos? I know that you just looked at our senior photography contract and you've answered a bunch of these in the Facebook group. So I'm also going to have you take this one.
yes. So, if they are over the age of 18, then technically they can sign the contract and it can be legally binding. Now, hear this. If they are under the age of 18, I don't care if their birthday is the next day after the shoot, they cannot sign that contract because it's not going to be legally binding. You have to have a parent or guardian sign it. It's just the law. So if they're in college, they're probably over the age of 18 and they can probably sign the contract. But if their parent is paying, it would be a third party payer addendum situation. So you're just going to want to have them sign that extra contract that they're paying, but your client's technically the college senior. Usually, high school, you're going to have the parent or guardian sign the contract and they need to be at the shoot. You can't just photograph a minor and have no parents there. They need to be at the shoot, they need to be present, and they need to be the one signing the contract, paying for the contract, all of those good things.
Yeah, yeah, we've just seen too many issues. I know senior photographers do things differently. We're always giving you our legal take on best practices here. So again, take it or leave it in terms of like having the parent at the actual session.
Sure.
But can just open up a can of worms to things going wrong. And so if they are under 18, it would definitely be best legal practice to have the parent there. And I think like third party payer addendum situation with seniors can get a little bit sticky. If all else fails, just have everybody sign the contract, right? Like have
Absolutely.
parents, have the high school senior. Also, if they're like Alicia said, turning 18 between like the shoot and delivery of the images, or after delivery of the images soon thereafter, you could get into a situation where now they are of the age of majority. And that's what Alicia is talking about here under contract law. It's like age of majority has to be 18. And you have a model release situation now where their parent signed off on them. So you're good there because the legally, the legal guardian or parent can sign off for a model release. But now they are the age of majority and they could rescind that, and so you kind of want their
Great point.
signature on it as well. So yeah, we're talking like too much here, but just best case scenario, have if parents are involved in the booking of the senior session, have them sign. If they're over 18, have the senior sign too. If they're under 18, don't have them sign at all. If they're close to being 18, maybe just have them sign, but always, always have the parent sign because there's no legally binding contract if they're under 18. Okay, moving on. If I post wedding photos that include guests, do I need a model release from everyone pictured? Okay, we're back to model release land. Alicia, what are your thoughts on this?
So, in your main wedding contract, your clients are kind of signing the fact that you can use the photos from the wedding. It gets a little sticky when you're using guest photos on Instagram or your social media or website. Here's kind of our take on it. Legally, you probably should have a bottle release and you can ask the client to get that from the guest. Or you can post it. You have like that base agreement with your client. Guests are coming to the wedding knowing they're getting photographed. There
Yep.
is that reasonableness of getting photographed. And unless that guest comes back to you and says, "Hey, I don't really want this on your website," you're probably okay. So there's kind of two options. you can have the model release and you can get that from that specific guest. It might be a little harder. Or you can just go and post knowing that you have that base agreement with your client. And then if something happens where they want it taken down, I would just take it down at that point. You have other photos with your clients who have agreed to be on your social media. So that would be my take. Do you agree with that?
Yeah, it's implied consent for a model release with people at large events when they see photographers, they see videographers. Like there's an implied consent that you might be a guest in a photo in the background. It's more like I think sometimes we've had weird wedding party situations where there's like someone who just does not want to be the face of your brand for whatever reason, and you've like plastered it all over your marketing and advertising. I mean, they have the right to like rescind an implied consent that you never actually got in documentation format. So that's what Alicia is saying. And 99.9% of wedding photographers and videographers out there are under that impression that guests have an implied consent to their likeness and image being shown in photographs or videos. But just know, yeah, like there's a risk there. It's very, very, very small risk. It has not popped up very much. I've been doing this for 15 plus years, and I can count on one hand basically how many times that has happened. So there you go. I feel like it's a risk that we're all willing to take, and you can, and it's easy. Like as long as you have it from the couple themselves and they've signed the model release. Again, that's why you want two clients to sign wedding contracts. For that reason, is you want the model release from both of them. You just have to be cautious with like photos that would display other people in them. And as Alicia said, like best legal practice at that point is, okay, I know I'm going to use this. This is going to be on a billboard. This is going to go to venues. This is going to be in XYZ marketing and advertising locations. You may just want to go get a small one pager model release form signed by whomever was in that, or at least get consent from them, via message or something along those lines.
Have I ever told you that happened at my wedding? I
No.
had a family member who I had posted all my pictures and our photographer had posted some pictures and he wanted to be in none of them. So I had to go to my photographer and ask her to delete them. I had to delete them
Oh,
as, the family member and it was the whole thing. It was fine. I was happy to do it. He wasn't in that many photos, but it does come up, you know,
oh, I said
family.
only on one hand. Now we're on two hands, people. So, yeah, I guess it's becoming more of a thing. I think people also just are more concerned with privacy, and we just all need to respect that. So, we
Absolutely.
just kind of know the name of the game now, and we all have to be aware that that could occur. And so, just understanding that sometimes we're just going to be able to use the images that we have a proper model release signed from. All right. My client is asking for the raw files from their session. Can I legally say no if it's not included in the contract?
Oh, I think you definitely can. If it's not included in the contract, there's enough gray area. You can do what you want. We do have clauses in our contracts that say that we're not going to release the raw images. You can also give them options of if you are comfortable releasing raw images, it does come up. Maybe you have a really high profile client, you can put language in there, but ultimately, we usually don't recommend you give any raw images. It would just tarnish your brand, and there's just some copyright issues with that. So, definitely have it in your contract, but if it's not in your contract, you can still say no. Absolutely.
Yes. Yes, yes, yes. Raw photos. You guys go back to all of my episodes in July of 2024. I go through raw images and what to put in your contract and how to use like raw file delivery contracts, things along those lines. And that was Sepia Gate World back in July of 2024. So I will stop there. I'm not going to go down that lane at all because I could talk about it for hours, and Alicia just summed it up perfectly. Okay. This is a really it's kind of a lengthy question, but I think it's really good. I use one of your wedding contracts, and there is a section regarding reproduction that states client and client's agents, including family and friends, further agree not to supply images to any third parties or vendors without the express written consent of the company. A couple has asked me to remove the including family and friends language. Do I have to keep including family and friends language in there? And if I keep it, what is the reasoning? Okay, this was a really, really, really good question. And it actually came to our shop inbox because somebody had purchased a contract from us. And I love it when they get so nuanced. Clients have laser beam focused on contracts now too. This is like the perfect example to that. They are literally reading line by line. Not a lot of them, but some of them are. And they want to know what they're signing on to. They want to know what all their legal rights and responsibilities are under the contract as well. Um, and they had a valid reason to question this in terms of, hey, how can we legally bind family and friends to something that they haven't signed on to? And here's my answer to this. We put in family and friends as more of an indicator of, like, for example, such as who are the client's agents? Because a lot of times people are like, clients and clients' agents, what does that mean? What is happening is you, as the client, are now legally bound to everything you agreed to under the contract when you send that gallery to a family or a friend. So, and we know that that's happening all the time in the online space. Hey, here's my gallery, download whatever photos you want, post them on social media. And this in particular with reproduction, you don't want a third party who really has no communication or interaction with the photographer or whomever the company is under this contract to send them to other third parties, such as other vendors. And we've gotten this a lot where, like, a mother or something gets the images and then she's in contact with the planner or the florist, and then they ask for the gallery and she just sends the gallery over to them. And now the photographer has, has given basically these images to someone without their consent. And
Right.
so that's kind of where this is all coming about. And yeah, so there is a legal reasoning behind why we put it in there. It's more of clearly defining what clients' agents are and what that includes. And I would tell people not to take that out of your contract. So we have it in there for a reason. Anything else, Alicia?
No, I would just say, if a client's asking you to edit things out of your contract, just, you know, proceed with caution.
Yes, especially if it's one of our contracts. We've been meticulous at looking through them and updating them and making sure that the language in there is exactly how we want it to be as lawyers who are experts in the field. And so just know that you have lawyers that are writing these contracts for you. They're not written by some AI platform that regurgitated something horribly for you. You didn't get it from an industry friend that you have no idea where that came from, or Google. They were written by us and they have language in there for a very specific reason. We're not just going to like randomly put language in there that's going to be invalid. Like, that's what clients are trying to pick you apart for. And yeah, proceed with caution. I always tell people though, it's like a yellow flag. Don't think of it as immediate red flag. I don't love that. Sometimes clients just want clarity. And if you're able to show professionalism and ultimate communication, that you understand your contract and you can adequately convey to them why certain things are in there, man, they're going to book you all day long because they're like, oh, this person knows exactly why this business policy is in there. So this is a really good reason on why you guys should go to our TLP community on Facebook, because you can ask questions like this, like, hey, my clients are asking about XYZ. Can you give me some legal reasoning as to why I wouldn't want to negotiate that or change that in my contract? And myself and Alicia and our other attorneys on the team, like, they are in there answering these questions. We are all in there, as well as other people have experienced similar things in the industry, and they'll give you feedback as well. So then you can, have that knowledge base and be able to respond very professionally and make sure that you are, enforcing and standing by your contract. All right, a couple more quickly. This is a venue situation, and I'm gonna have you answer this because I've done an entire webinar on this. But my couple sent me a contract from their venue asking for my photos that they signed. So the clients signed a venue contract, and in there was like some little provision that said you have to give me all of your photos from your event. Am I legally required to give them the photos? Or if it's like an after kind of one pager document. We've seen this too, Alicia, where venues like they've already signed with the clients and now like 14 days or 7 days prior to the event, the venue is like, oh, you need to sign this too, or you can't show up.
Right.
And it says like, you have to give me all of your images and videos. And the clients are like, am I legally required to sign this? Like they're kind of being a little threatening here. What is your answer?
So if you're a client and you're having a venue asking you to hand over photos that aren't legally yours, you don't have to sign that. What I would do instead is I would go to your photographer. I would say, hey, the venue's asking for these. And hopefully the photographer is going to handle it and go to the venue and explain that they're the copyright owners and that they would be the ones that would license those photos to the venue. And hopefully your client doesn't even have to be involved in that. So that would be the ideal. Clients only have a limited license to use the photos for personal use once they get those galleries from you. So they do not have the rights to sign over your photos to someone else. That would be more you working with other vendors to give those photos to vendors through licensing agreements, or maybe it's even an email, depending on how you want to handle it. So hopefully that answers that question.
Yeah, I think clients are just being stuck in the middle right now where venues are trying to skirt around even going to the photographer or videographer for whatever reason. I think we've seen it a lot where there might be some like bad blood or like venues are just like photographers haven't given us things. So we're just trying to like figure out how to get, images or videos from our venues so that we can use them for our own marketing and advertising. Like I see it from both perspectives, but at the end of the day, Alicia's right. Like a client only has a limited personal license to use. They cannot give those images to third parties for commercial use. And that's exactly what this venue is asking for. And so if a client were to get a like one pager document that they're like, hey, should I even sign this? And then they're coming to the photographer. Great. You're in a really good position as a photographer because your clients kind of know that they shouldn't be signing this. And this is feeling really weird. And it is your images copyrighted by your company and your photography business. And at that point, then you have all the leverage and you should be contacting the venue and you just tell your clients, like, thank you so much for bringing this to my attention. I'll take it from here. There's no reason for you to be involved whatsoever. Like, I'll give you the link to the gallery, no problem. And you can share with your family and friends. But yeah, this is one of those third party situations where they're trying to use it commercially. And then, we'll work out an agreement in some respect that works out for both of us. And your clients will be like, great, sounds good. And then you can, of course, you can play nice in the sandbox with the venue and other vendors, and you could give them highlight images to use for like website and social media only, which is like a limited commercial license to use. And then anything above and beyond that would need, additional use equals additional compensation because you own the copyright to those images and you require credit and then probably some type of non-exclusive licensing agreement, as Alicia stated. So there's our answer there. Okay, a couple more. Client reviews. Can I legally use a client's review on my website or social media without asking them first? Alicia, what do you think?
I think that there are some, it's kind of a gray area. We would recommend that you get an agreement signed. It's just a release of statement.
Yep.
And that way it's just crystal clear. Can you do it? Potentially. It depends on how you're using it. But overall, you're going to want that permission. That way you can use it everywhere. You're never going to fear them coming back at you and being like, why are you using my name? You just
Yeah.
have it in writing and it's there and you can use it for years and years and years.
Yep, and it's when the name is attached to it. The name with like a first letter of their, last name kind of thing. So, yeah, always best or at least say, would you be okay with me using this on my website and social media and other marketing materials and they say yes back? Good. You've got it in written documentation form. And then the other thing that we would suggest too is like just pop up a Google form or something that has a testimonial release and you just have your clients like quickly sign that. It's really, really simple. And then boom, you have, documentation and proof beyond them just saying yes in like a DM on Instagram, something like
Right.
that. Yeah, great answer there. Okay. Business change ups. I am rebranding. Do I need all my old clients to re-sign their contracts under the new business name? This one is so good. And I think people do it all the time where they're like, hey, I'm changing my business name, but I'm still completing like, 6 to 12 client projects right now. What do I do?
Yeah, I wouldn't. And here's why. when you're resending contracts to clients, clients get a little scared. I mean, they've already gone through one contract and they're like, why are they sending me another one? If you are rebranding, all of your old contracts are still valid under your old brand, especially if you're keeping your LLC name. If you're changing your LLC, that's maybe a little bit different of a story because you want the contract to be underneath your new LLC, especially if the old one is dissolved. But if you're just changing your DBA, nothing legally has really changed that much to warrant resending a client contract. And it's just going to cause more anxiety with them and less trust with you by doing that.
Yeah, exactly. And if you are completely changing LLCs, like do not dissolve that other LLC that you originally had until you
Right.
have completed all client services and all contracts that that LLC is under. Unless they do sign a new contract, but like we said is that's not a good. I would not rock that boat. I don't like it. It's just creating like weird distrust with your clients. And it's fine. Like legally speaking, you are already under that same LLC. You can just operate under a different name now, and you're good to go. I would maybe send out a notification email that your name has changed, or like if your email address has changed, to let them know like it's going to be forwarded to this new account, and you'll be seeing, just overly communicate to people. Let them know what's going on. You don't absolutely have to send a new contract, and we just would definitely legally not recommend it, but keep that LLC open if you do have open contracts in place. Okay, Alicia, I think we went through a lot here. Thank you so, so, so much for joining me. I'm excited and I hope that this helps people, and I would love to do this again. What do you think?
Yeah, I would love it. We get these kind of questions all the time, and having this kind of platform where you can hear from two attorneys would be really cool.
Yeah, definitely. I feel like they only get it in the Facebook group. So we thought we would do it in another way for you all. So let us know, give us feedback on this episode. And of course, if you have questions that you want us to answer, you can always send that in to us. You can shoot me a DM, you can shoot us an email, you can ask us in the Facebook group. So thanks, everyone. And we will catch you in the next episode.
Bye.
Thank you so much for tuning in to today's show. Be sure to visit thelegalpage.com for contract templates, blogs, and additional legal resources. If you found this episode helpful, please share it with a friend or on Instagram with your favorite takeaway, and make sure you tag me at The Legal Page. Sharing is one of the best ways you can support the show. And if you've been tuning in for a while and you are finding value in these episodes, it would mean the world to me if you popped over to Apple Podcasts or Spotify and left a rating and review. Hearing your feedback absolutely inspires me to continue creating podcast content. Lastly, you can join my free Facebook group at tlpfacebook.com, and this is where you'll get access to me, my legal team, and thousands of other entrepreneurs for unlimited business and legal Q&A. Until next time, my friend. Wait. Before you go, please don't close out this episode just yet, because I need to make sure that you're actually legally protected in your business. Listen, if you're booking clients, delivering services, selling offers without a solid contract in place, you're basically building your business on sand. One bad client, one miscommunication, wait, I thought that was included, and like poof, it can all get real messy really fast. That's where I come in at The Legal Page, where myself and other lawyers make legally legit contracts for small business owners just like you. Yes, that's right. It's written by actual lawyers who are experts in the field and not some AI bot, because let's be real, those will not hold up in court. I've reviewed them and they are awful. So here's the deal. We've got our biggest sale of the year coming up in just a few weeks. I'm talking a huge percentage of all contract templates and a la carte clauses and short forms and legal guides. And I'll give you some exclusive bonuses that I only give to my insider list. So if you want early access and a little legal love from me, go sign up now at tlpinsider.com. It's free, it's fast, and you'll be the first in line when things kick off with the sale. So don't wait till you're in a mess to get your contracts in order. Be proactive. Go to tlpinsider.com, pop your name on the list, and I will see you in a couple weeks. Okay, now you can close out the episode.